Good morning, everyone. I think the time is now 9:30 a.m. and so we'll reconvene our hearing. Can I just check that everyone can hear me clearly? Give me a wave at the back there if you can hear me. Fantastic. Good. First of all, let's just summarise who we are and what we're doing. So this is day 2 of a hearing called to determine an appeal by Mr. Simon Brooker of Brookwork Homes Holdings Limited, which results from the decision of Wealden Council to refuse planning permission for the erection of 49 dwellings, access, landscaping and associated infrastructure at land north of the A272, Buxted, East Sussex, TN 22 4BA. Now, for the benefit of those who were not here yesterday, my name is Mr. Tweddle, and I am an inspector appointed by the Secretary of State to conduct this hearing and to determine the appeal. Firstly, do we have any new attendees that were not present yesterday? No, that's great, so we don't need to circulate an attendance list. And can I just at this stage politely remind everyone to have mobile phones either switched off or onto silent mode, please. So, we are going to pick up where we left off yesterday, and I think we had concluded our discussion on main issues and our key points of discussion, and we were about to move on to other matters. So we're on agenda item number 4. This is an opportunity for anyone to raise anything that's not covered by our agenda or which has not yet been discussed. So, are there any other planning matters or material considerations that anyone wishes to discuss? And I'm going to look to interested parties and the members of the public first. Councillor Blandford, is it? Yes? Pardon? We discussed that yesterday afternoon. Do you want to talk about that more? What particular element? Would you like to just come to the microphone, please, for me? We did briefly discuss this yesterday, so I don't want to spend too much time on this. Go on. Thank you.
So I'm speaking as the chair of Buxted Parish Council, having been a member of the Parish Council for 15 years and a resident of over 30 years, and I'm not sure that I recognise the description of Buxted by the appellant yesterday. The development and affordable housing. High Hurstwood, Buxted is made up of 3 separate entities, 5 Ashdown, High Hurstwood and Buxted. High Hurstwood is in the High Weald, so development is restricted there. 5 Ashdown has several planning applications in the pipeline, and one at Cooper's Green has started. Were these figures regarding affordable housing taken into account when the statistics were done? And the open spaces. I actually have here a footpath which gives ample opportunity for people taking the benefits of fresh air and exercise. From Buxted you can access the Vanguard Way and walk if you wish to Croydon. Better bit would be the seaside at Newhaven. You can walk onto Ashdown Forest, northwards and southwards to Cranfield and Blackboys, passing a few pubs for added interest. Why would we need a green to perambulate round a housing estate? And my comment is only the residents of the development would use it. And play equipment, there's perfectly adequate adult and children's play equipment on the same site as the surgery, not far from the development site. Children's playground is well used with free car parking. Adult equipment is not well used, although the zip wire is popular with some. A standalone development was built about the same distance as the one under discussion out of 5 Ashdown, with a playground. Residents were not welcomed by the residents of that development who lived on the estate, who complained about visitors' cars taking up 3 their parking spaces, an intrusion of privacy, so it didn't work in Buxted or Buxted Parish. And social mixing, unless you also build a village at Buxted, a new village hall, I am unsure where you expect people to meet up and socialise as you assume is the benefit. Buxted is so land poor it cannot find space big enough site for a hall and its attendant parking. And the bungalow figures, I'm not sure where they came from, and you cannot assume people will move out and downsize. I was never aware there are so many bungalows in the area. I would say the opposite occurs. Too many, too big, albeit expensive houses. What did happen in Littlewood Lane and Higgler's Close, both newer developments, was that the smaller houses and bungalows were built. People moved in and added rooms to make bigger, spectacular backfire of providing smaller houses. And the lack of safe footpaths and East Sussex County Council ability to make changes. And obviously, an obvious flaw in your plan is that people will walk into Buxted and walk their children to school in the opposite direction. For over 10 years, Buxted Parish Council had a dialogue with East Sussex County Council Highways saying the path was not suitable to walk children to school, and there is very difficult traffic situation at school beginning and end of day, as many places. East Sussex County Council constantly come back to us saying doing anything about the path is not a priority. In desperation, after ineffectual attempts by East Sussex County Council to improve the pathway, local residents took to clearing the debris off the path. The parish council paid for extra cuts and hired a lengthman to do the work in a timely fashion. The reality is this is the narrowed A272 and cannot be widened. East Sussex say we cannot have a crossing on an A road. However, if the tenant managed to do so, it will have exceeded where others have failed constantly for more than 10 years. And when you're out on site, I would urge you to have a look at the path by the lodge, and the pathway is slightly wider where the development would be. But if you think of people walking to school with a buggy and a child in tow, it's not a pleasant or particularly safe experience. And under the sill, it may have escaped the appellant's attention, but Buxted Parish Council objected to the development, and it would be fair to say that we'd rather have that, no development, than the sill money. And so do the benefits outweigh the harm? So can it be argued that the benefits of the scheme, as outlined by the development, outweigh the harm, the setting of the listed assets, when these benefits would only benefit the lives of those who live in the development, not the residents of Buxted?
Thank you very much. Do you have the copy of your notes? Fantastic. Do you have a copy for everyone, or do we need to get them copied? Just in a moment. Thank you. Did you want to, was it Mr. Chitty, is that right? Would you like to come forward?
Thank you. I'd just like to also talk about the path proposed for around the site. So I understand EN27, saved policy, talks about privacy and states the proposed development should not create an unacceptable adverse impact on the privacy and amenities of adjoining developments and the neighbourhood by reason of scale, height, form, noise and traffic movement. In terms of the proposed path, as per the map, that goes at the back of all of our gardens, about the cluster of houses on the bottom end of Station Road, passes all of our gardens, therefore disrupting our current privacy and also very concerned security concerns from my neighbours and also myself. And it buffers all along the land adjacent to the old mill. And again, I did mention yesterday about the real concerns of the path going towards the pillbox, which is just a metre or so away from the border of our property, We do not have fencing, we do not have anything like that to secure, because currently we do not need to, because there's no public access whatsoever. And similar to the concerns of that the gentleman raised yesterday of the lake, all of us residents would have very similar concerns, and particularly for the old mill that extends all the way down the border, and as I say, has no border fence, because we did not want to just put a border fence through an ancient woodland. That would be harmful to an ancient woodland. There are no border fences currently in existence. But if suddenly the public are allowed on that spot, that would significantly increase trespass and also impact the privacy of all of us adjoining sites. Thank you.
Thank you very much. I've made a note of those points. Are there any other matters anybody would like to raise? Okay, thank you. I'm going to turn to the parties now to make a brief response to what they've heard there, and any other matters that they want to bring to my attention. In doing so, it would also be helpful if they want to address any issues that were raised yesterday by Mr. Wickham and Mrs. Percy. So if I could turn to the council first to make any submission in this regard that they wish, just in response to what we've heard, or if you want, you may want to cover those matters in your closing submission.
Unless you've got specific questions for us about any of the questions any of the issues raised, which we'd be happy to answer, we don't intend to address any of the points made by local residents.
I don't for the council side, no. I'll turn to the appellant's side now, and the same question really, and address those issues. The one point I did want to ask you to cover was actually just to address the point that this is just raised there in terms of the footpath and proximity to boundaries and so on. If we could just touch on that point really, please, just to satisfy me.
Yes, sir, of course. Would you like me to start with that since we're here? So, yes, Ms. Tucci is absolutely correct in what she says. EN27 seeks to protect residential amenity, but in this case, there won't be an issue in my submission. The reason for that is the proximity of the path to residents' gardens just isn't particularly close, about 5.5 metres away. And also, if you look at our proposed planting plan, you'll see that there will be some screening proposed. So in terms of residential amenity issue, I don't think there'll be one.
Thank you. No, I'm not inviting further comments from the public now. Do you want to continue with any other points?
Yeah, sure. So just in terms of just Blandford on behalf of Buxted Parish Council, affordable housing, no, those developments haven't been factored in to the submissions we made yesterday. And the reason for that, sir, very simply, is that affordable housing hasn't been delivered, been permitted, but none of those sites have actually commenced. The Vanguard Way, I think we're slightly talking in contradictory terms. We're praying in aid of the provision of public open space, primarily, as a public benefit. We do attribute some weight to the delivery of a footpath, but the Vanguard Way doesn't enable residents play space. So we still regard both of those elements as a benefit, and don't think the presence of the Vanguard Way diminishes the benefit of either the public open space or the additional footpaths which we're creating. The suggestion that there's no need for a playground, I think what we're actually doing, providing a public a contribution towards children's play space, which conceivably the council could spend elsewhere in the district where there is a need, if that benefit remains. The suggestion is that social mixing will be unable to take place because there is no village hall or community building. Well, we say, sir, the public mixing would take place at the public open space adjacent to the development. The bungalow statistics come from Wilden Ward Profiles 2019. That's available on the council's website under a section called Facts and Figures. The suggestion that the public footpath which connects the bulk of the settlement of Buxted and the school runs past the hillside, not being suitable for individuals to walk on and take their children to school. Well, happily, sir, that is being widened as part of the development should it go ahead at the request of East Sussex County Council. So hopefully we'll go some way to resolving that issue. And just because the council would rather not have the development does not mean that the SIL money that would come along with it is not a benefit. That's everything.
Thank you.
From me, sir. Thank you.
Anything else from the appellant side at this stage? Thank you, Mr. Cameron. Okay, let's move on then to a discussion around planning conditions, about conditions and planning obligations. So we'll look at the obligation, I think, first. Now, as I mentioned earlier, any discussion about conditions and planning obligations are made without prejudice as to the outcome of this appeal. So let's start by looking at the planning obligation, and we'll discuss conditions a little bit later. Mr. Cameron, I can see you're poised to come in.
Anything else we wanted to say? We did want to just make a response to a point made by Mrs. Percy yesterday, if we could, which is under the any other matters.
Can we make it briefly?
Yes, Mr. Best is going to make it.
Yes. So, sir, if you could turn up the statement of common ground, what you will see on page 17 is a table of proposed site allocations. Now, those are interesting to us because they will all result in less than substantial harm. And the point was put to us by Miss Percy yesterday that, well, okay, thank you. The point was put to us yesterday that, well, you should just go and build somewhere else, and that there are other available sites which are more appropriate. And what the council's efforts at plan making tell us is that there are no more appropriate sites, because these sites will similarly cause less than substantial harm, which the framework directs you to give great weight to. Now, the important context for this plan is that it was predicated on delivering 953 dwellings per annum. OAHN now stands at 1,433 dwellings per annum. That's a difference of 480 dwellings per annum, or 9,600 dwellings over a 20-year plan period. So it's likely that we're going to need more sites, not less, and that it's likely that these sites will be developed and the council will still be looking for further suitable sites. Just in terms of the sites themselves, DU7 is visible from the appeal site, similarly visible from Buxted Park.
But I don't want us to get drawn into other sites particularly too much. I think you've made the point already quite well.
Okay, well, if you have the point, sir, I won't continue. Very briefly, in summary, it's that the council cannot meet its housing needs without causing harm to heritage assets, and doesn't intend to through its attempts at plan making.
And I have made that point.
Thank you.
Thank you very much. Okay, let's just return then, if there's nothing else from the appellant side. Thank you. Let's just return to where we were about to go, which was to look at the planning obligation that's been submitted. So let me find that. So a final signed planning obligation has been submitted for consideration for this appeal and to aid our discussion. I do have now a signed and dated copy that's been provided. Can I just confirm that both parties have got a signed and dated copy? And the LPA?
I haven't got an original in front of me, but I've got a copy of it.
You have got a copy, okay. And the local planning authority?
Yes, sir, we have a copy, and I know the one that Mr. Robbins provided you yesterday was redacted. We've got an unredacted version if you'd like it as well.
That would be most helpful, actually. And can you confirm that that's been sent through to the case officer at the inspectorate?
Yes, just now.
Fantastic, that's great. I wonder then if I can turn to the appellant and ask you to briefly talk me through the legal agreement and summarise what obligations it would secure.
Yes, sir. The owner's covenants are in clause 4.1, and the owner,
Page number?
page number 17 in the paper copy. So that's the clause that bites, and it requires the owner to comply with schedules 1 to 10 in the deed. I should draw attention to clause 2.6, which is above on the same page, which is what's known as the blue pencil clause. And what that provides is that in the event that the Secretary of State or you as the inspector acting on her behalf expressly states in your decision letter that any of the planning obligations contained in the deed do not meet the tests set out in Regulation 122 of the Community Infrastructure Levy Regulations 2010, then such planning obligations shall cease to have effect. I draw your attention to that, sir. It's a perfectly normal clause, and we are not saying that any of these obligations fail to meet those tests. We accept that they do meet the tests. But you took a different view. There would be the consequence which is set out there. And I also draw attention to clause 3, which makes provision for when particular clauses come into effect. So really what one needs to do is to look at schedules. I don't go through them in detail, but schedule 1 to 3 deal with affordable housing. And this is a planning obligation which is agreed with the council, so it meets the council's requirements. That's where the affordable housing provisions are set out. Then if we go to Schedule 4, we have the self-build and custom build, and you asked before whether that was secured by a condition or obligation. It's secured by Schedule 4. We then have at Schedule 5 the SANG's and SAM's contribution, to use the acronyms, but they are the measures taken to avoid adverse effect on the integrity of the European site, which we discussed during the hearing. And then at Schedule 6, we have highway provisions, and so there's a provision in paragraph 1 of Part 1 that prior to the commencement of the first dwelling, the owner will enter into the Section 278 Highways Act 1980 agreement with the County Council, paying all of the County Council's proper, reasonable and evidence legal costs relating to the Section 278 agreement, and to enter into an agreement to secure the carrying out of the highway works. And if you go to Part 2, you find out what the highway works are. That includes improvements to the existing foot raised by Councillor Bamford. And there are other provisions relating to transport, including the bus service contribution and travel plan provision as well. And so if you want to know how much each contribution is, you go to the definitions clause, which is clause 1. So, for example, on the
page number for that?
Page number 4, sir, bus service contribution is £200,000. And total contributions mean the SANG's contribution, the SAM's contribution, the bus stop clearway consultation contribution, the bus services contribution. So, sir, I don't know whether there's any more detail that you'd like me to go into, but essentially there's a covenant to comply with the provisions in the schedules, and the schedules secure all the obligations that we've referred to.
That's helpful, thank you. I have no further questions on that. It's just helpful to briefly run through and summarise what we've got before us. I've also seen the still compliance statement from the local planning authority in response to some of the questions I raised as part of my pre-hearing notes. Can I just check with the local planning authority? Has the LPA's legal officers had sight of the proposed legal agreement, and are they content that it would achieve what is intended?
Yes, sir, that's correct.
They've had sight of it?
Yes.
And the second part of that question was, and are they content that it would achieve what is intended?
That is also correct, yes.
Are there any further comments from the local planning authority in terms of the planning obligation? Anything further from the appellant's side on the planning obligation?
Only one thing, sir, which goes to the question you asked the local authority. This is a planning obligation by deed of agreement. So the local authority, it's not a unilateral obligation. So it's a bilateral, so the council have been fully involved in this preparation of the agreement.
Thank you. That's been quite clear, and I think we can take that at face value. Therefore, I have no further comments or questions on the planning obligation, unless there are any questions from anyone else. Okay. Let's move on then to a discussion about planning conditions. In the event that I do allow the appeal, and that's not to say that I will, my decision will include a section setting out why I've imposed any necessary planning conditions, and particularly why they are reasonable and necessary. I should also point out that I will make some minor changes, or may make some minor changes, to the suggested wording of those conditions in the interests of clarity, precision and enforceability. That's usually a fairly standard practice. for inspectors. I wonder if I can draw everyone's attention to the list of suggested conditions that are set out in section 9 of the Statement of Common Ground. And I think we're looking at pages 24 to 36, that statement. Everybody got that? Yes? I think Mr. Robbins did touch on this yesterday, that there was potentially some progress made between the parties in terms of conditions that may have been in dispute. I wonder, before I run through that, if the parties could update me on that.
Ms. Best, do you want to?
I certainly can, yes. So what we have agreed with the local authority is that the condition relating to foul drainage will be switched from a pre-commencement condition to a pre-occupation condition. Council has sent me wording very helpfully yesterday, which I'm content with. So with your blessing, we'll agree that as a condition and move forwards.
Can I have sight of that wording, perhaps? That might be useful. And how will we make that happen?
If I may, sir, I'm happy to send it over to by your case officer now. Yeah,
that would be most useful. That's good. I do still need to run through the conditions with the parties, though. That is helpful, and I think there may have been another disputed matter, but we'll.
Shall I just clarify on the other ones what's still in dispute? So there's this question about implementation period, and I understand that it's quite a narrow dispute. Ideally, the council would like it to say 18 months. The appellant is prepared to accept 2 years.
So we're actually content with 18 months. The concern was over the foul drainage condition, and so having had that concern alleviated through the council's revised wording, we're now content with 18 months. So if that's what you deemed fit to include, we'd have no issue with it.
And let me just check. I understand this is a benefit being put forward by the appellant to enable a more swift implementation of the planning permission. But for those maybe not familiar with this, the standard timescale for using a planning permission, I would call, rather than implementing, using a planning permission is 3 years, for a full planning permission, and you're offering a shorter curtailed period as a benefit to build out this scheme, given the housing supply situation. Is that my right understanding?
Yes, sir.
That's contained in the council's housing action plan as a mechanism by which they can address their housing shortfall. So we draw support for the measure from that.
So that's set out where? Sorry, say that again.
In the council's housing action plan, because the housing delivery test, in the event you don't meet it, you're then required to prepare a housing action plan in certain circumstances. The council has prepared one, and as a measure to speed up delivery, it has suggested that this is a good idea, and we agree.
Just to help you, sir, it's on page 37 of that plan.
Thank you. I think that deals with that. One of my first queries was going to be that looking at that list.
And then, sorry, the other one, which I think hopefully is also used, the only other discussion was this point about landing gradients at road junctions, and the local authority no longer dealt with.
I was going to make that point, actually. I was going to touch on that as to whether that was actually necessary or reasonable on that basis. Okay, that's useful. Can we just turn our attention to that list? And there's a few things I want to run through, and I'll ask questions backwards and forwards to the parties. This can get a bit like tennis at some point in this session, but it's useful that we go through the technical details because they are extremely important. And what I would say as well is, whilst an appellant may be content with a condition, it is still my duty to consider whether that condition is necessary, reasonable, and meets all of the other policy tests and legal tests required for its imposition, so that it is not then later judged to be unreasonable at a later stage and is then removed for some reason or threatens the decision that may be made. Okay, let's turn our attention to the conditions then, which are set out on page 24 onwards of the schedule. Sorry, beg your pardon. Statement of common ground. I'll get my words out today. The condition 1, and I'm mindful as well, we've got pre-commencement conditions here, and I'm going to highlight those as we go through. Because what I'll ask at the end is that the appellant will need to put some confirmation to me of their agreement of those pre-commencement conditions in accordance with the associated regulations. I'm looking at you, Mr. Vest, because I hope that you'll understand what I'm talking about in that regard.
Yes, sir. Thank you.
Good. So condition 1 and 2 is a programme of archaeological works. I notice this is pre-commencement, so if we can just make a note of that, because what I'll need you to do is refer to each one of those pre-commencement conditions as we go in your response to me. I have no issues with those as they stand, and they don't appear to be contentious. Condition 3 is a construction management plan. Again, this is pre-commencement. That would appear sensible, given what it's trying to achieve. But again, I will need the appellant's confirmation of that. Condition 4, so this is deliveries to and from the site. I think it is. I mean, is this really necessary if we're going to have a construction management plan? Would that not be covered by the construction management plan? I'll turn to the LPA, it's their condition, I think.
Yes, sir. I think it could be woven into the construction management plan condition. I think you're right. I think it could be woven into the wording of the construction management plan condition.
Well, I was thinking, does the wording even need to be there, or is this something that can be satisfied by compliance with providing that construction management plan? We have to be very careful that we're not turning conditions into informatives.
I think the point is that there should be a floor, if you like, as period for delivery during the construction. That's what we're trying to do. So again, I mean, no objection to incorporating it into condition 3, although what you're getting at, but yes,
But that could be achieved by way of weaving that into condition 3. Okay, I'll consider that. Does the appellant have any observations on this point?
Yes, sir. I think the approach the council's taken is a belt and braces approach, and I'm not sure it's sensible to rely on the quality of a construction management plan, whilst it's within the council's gift to say, no, you need to go back away and include such as times for delivery. If that were to slip through the net, it would potentially leave the amenity of the public exposed, and this condition mops up that risk. So personally, I think it's quite useful.
I hope that doesn't mean we're setting up the construction management plan to fail already.
But I don't have any certainty over who will prepare that or the quality of it. And so we're reliant on council's officer being diligent with it, and if sort of time pressures were to get the best of them, and I'm not suggesting that's likely in any way, this condition just requires a bit of a fail-safe mechanism.
I take the point. I mean, I'd always expect local planning authorities to exercise their functions and powers with highest level of diligence. Okay, I've taken representations on that point. Let's move on to condition 5, which again is a pre-commencement condition. Is this one of the drainage conditions you were referring to, or is it the next?
no, it's foul drainage, which is the and that comes at the end. So
Okay, so I've got condition 5, pre-commencement. This is surface water drainage scheme submission, approval and implementation. I was just going to ask, is this the planning authority's standard approach to surface water drainage, or I mean, is this LLFA sort of stuff? Sorry, lead local flood authority. Sorry for jargon.
I think the condition is a relatively standard one that we do impose, but obviously it has been written and tailored to this application through consultation responses, one of which was the LLFA at the time, as well as our own internal drainage engineer.
Any comments from the appellant on that?
No, sir.
I'm just noting that that is a pre-commencement condition that you have no issue with. Moving on to condition 6 then, which again is a pre-commencement condition, which is around maintenance and management plan for the entire drainage system to be submitted, approved and implemented. I've made a point here, and I'm just reminding myself what my point was, that the trigger doesn't match with the trigger for condition 5. I wonder if we could just look at that. Drainage should be provided in accordance with approved details for first occupation of the related dwellings, but we have a separate scheme prior to commencement. I suppose my query there is, how can we have a maintenance and management plan? Well, should we not have a maintenance management plan at the same time as we're having a complete surface water drainage scheme submitted and approved? It seems a little bit out of kilter to do one separate to the other. I mean, I'm looking for clarity.
I think the suggestion there is probably that any problem wouldn't arise until the taps are turned on, wouldn't happen until station. Equally, the appellant would likely do it all at once in any event. So,
likely isn't giving me any certainty, though, is it? I mean, I can see Mr. Cameron's face wincing there as a barrister. I'm sure he wouldn't like the term likely either.
no, but in which case we'd have no objection to making that a pre-commencement if that was a suitable trigger in your mind. Wouldn't cause any issues on the appellant's side.
Local planning authorities comments?
Sorry, we're
I'm on page 25 of the Statement of Common Ground, and I'm looking at conditions 5 and 6 at the moment. 5 is a prior to commencement of development, detailed surface water drainage system shall be submitted in support to and approved in writing by the local planning authority. And then condition 6 goes on to a maintenance and management plan for the entire drainage system to be submitted to the planning authority before any construction commences on site.
Is your point different, potentially unhelpful?
My point was on condition 5. No, hang on a moment. You may have a good point here, Miss Barnes. Apologies. We've got a scheme under 5 being submitted, approved, and then implemented before first occupation of dwellings. Yes? And then we've got a maintenance and management scheme submitted before any construction commences on site. That is pre-commencement as well. The trigger for detail should be submitted. Do you know what? That's my error. I apologise. I think they are actually in tandem with each other. Would you concur?
That's correct with my understanding of the
wording level is slightly different.
It is. I think yes. No, that's been my confusion. I think I've read over the page and I've read the trigger at the end of 5 as being the trigger for 6. I beg your pardon. That's been my omission.
I think, sir, for clarity, they probably ought to use the same language, because you could be right, sir, because any construction could be something that doesn't occur here, but in some ways you can commence development by demolition. There isn't any demolition here. Yes. Yeah. But it would be better if they're both the same. And it would be better in 5, the words in support to, in support seems
It's clumsy.
to me.
The language of that condition is clumsy. I wonder if I can ask the parties to get their heads together and provide me with some wording that covers the points that we've just discussed.
We'll just make sure that they're, and then that avoids any potential ambiguity.
Is that all right? Fantastic. That's great. Let's move on then to condition 7. Evidence that drainage works have been carried out. I mean, is this really necessary? Is my first question. And I'll put that to the local planning authority. Is this the sort of condition one would expect on your housing developments? Is this a standard condition that's applied throughout the district? I have to say I find it a little bit unusual that we're asking for evidence to be submitted that a scheme's been carried out. While the LPA have some discussions with each other.
We haven't objected to it, but start applying the test, it's not necessary because condition 5 requires the drainage shall be provided in accordance with the approved details before first occupation of the related dwellings. And that's good enough. And by good enough, that is achieves the aim which the local authority is seeking to achieve. And can't see that 7 meets the test of necessity. But it's in the statement of common ground, so I'm not pushing it too hard, but you've asked the question, that's our answer.
Is it particularly in relation to this condition? Yes, go on then. I think that's fine. I think we're straying back into planning merits and matters. All I'm doing at the moment is scrutinising a set of conditions that may or may not relate to a development that might get planning permission. And I'm looking at the policy and legal tests and applying them to see if the conditions are robust. I'm not wanting to open a can of worms of going back to discussing issues. I've heard the point that you've made. So I think from the summary of that is the appellant says that it wouldn't necessarily meet the test of necessity, and the LPA isn't necessarily disagreeing with that point. Pardon? Thank you. Let's move on then. Condition 8, no discharge of foul or contaminated drainage into the drainage system without treatment. That would seem particularly reasonable, would it? Any comments from the parties on that condition? I take that. I have no questions on that condition. Let's swiftly move on to condition 9. Access not to be used until visibility displays are provided. Looking at my notes. And I'm just wondering about how precise is that? Which access are we talking about? And when you say not used, are we talking construction traffic? Are we talking residential use by residents of the occupied dwellings? Just wondering about the precision. The access shall not be used until visibility displays of 2.4 by 10 metres provided in both directions and maintained thereafter. It just feels rather blunt. The access. Which access? The vehicular access with the A272? So we're talking vehicular access. So if necessary, I could tidy up the wording on that one. And there'd be no objections to either side on that. Thank you. Any comments? Side? No. Condition 10 is a pre-commencement by the looks of it. No development and survey of the adjacent highway is carried out. Has been submitted and approved, and any damage caused to the highway is a direct consequence. I mean, I'm looking at tests of necessity and reasonableness again here for this petition. Any comments from the parties?
I think essentially what the condition is seeking to achieve is if you break it, you fix it. That doesn't seem unreasonable to me.
Breaking off-site things?
Would it be covered in the Section 278 agreement?
So
that was my understanding, so that it would be covered in the 278 agreement.
It would be covered there. So it isn't necessarily necessary here. So we're talking about, we're verging into other regulatory regimes, aren't we? Are we?
I think we are. We're also got a condition which is trying to impose an obligation to rectify damage on the highways, which is going into other regimes, and you have to, the condition's imprecise apart from anything else as well, because it have to do a survey which is submitted and approved in writing by the local planning authority, and there's no mechanism for determining how you assess any damage. So it's got all sorts of problems, and if it's going to be covered by the Section 278 agreement, not necessary, that should be the end of it.
Is it the LPA's position that this condition could be covered by the 278 agreement? Is there a problem?
Sir.
There is no necessity for this condition. Thank you. Let's move on to condition 11. We've got no occupation until vehicular access has been constructed. And I think the right place. No part of the development should be occupied until time such as vehicular access serving the development has been constructed in the position shown on the approved plan. If we've got a plans compliance condition, which we'll talk about, and if we've also got condition 9, which we've already talked about, then have we not already achieved what this condition is trying to achieve? I'll turn to...
So, reading it, condition 9 is about a visibility display, and condition 11 is about construction of the actual access. You could have a visibility display without the access, and you may, during construction, not have constructed the access as shown on the plan because you've got construction vehicles going in and out, but for highway safety, you need the visibility display. So there is a difference between the two, but rather than just on the approved plan, a plan number should be specified, and then you're going to ask me what it is, and I'm going to turn to Mr. Best. But
Awfully nice of you. I'm just wondering, would it be better to wrap this up in condition 9, perhaps? Now I'm thinking about it. I mean, national guidance says that we should be trying to minimise the number of conditions on planning conditions. And I'm just thinking, where we've got overlap sometimes creates uncertainty, ambiguity, for the reasons we've discussed. I'll turn to the LPA and see what your thoughts are on that.
My instinct is they are all similarly the requirements to build in a plan. That's one thing. 11 is definitely no occupation. I think there is a helpful conceptual difference having all three separately, and that would actually...
Following that school of thought further then, you'd be happy for visibility displays to be provided for construction vehicles to go in and out of the site without the potential surface and construction of the access said vehicles to use. That's what could potentially happen. Following Mr. Cameron's line of thought, is that we could end up with visibility displays provided and edges or whatever ripped out, but a muddy, trodden entrance for construction vehicles to use, relating and then resulting in debris on the highway, creating highway safety issues.
Isn't the point we don't construction may well be a difference? That's what kind of
I don't know, you tell me.
Well, I don't know how the construction management plan is going to work, but it seems to me this is a reasonable way of planning for it with enough flexibility, ensuring that nobody's going to be living on this development based on appropriate access.
I think what I'm keen to ensure that flexibility doesn't turn into ambiguity. And I think what we're talking about now is potential ambiguity in terms of what the conditions are trying to seek to achieve. Any further thoughts from the appellant?
I don't think there's anything to add. I think there is a distinction between 9 and 11, because 9 is dealing with any use of the access, and 11 is dealing with a specific access arrangement when the site's up and running. 9 could be made more precise by, rather than just the access, you've already raised the question it should be the vehicular access. It could be the access shown in the location identified on drawing number, whatever it is. I noticed from the plans that there is an access plan. There's also a vertical displays. So the appellant's position is the two different conditions are justified, are necessary, meet the tests. They're serving different purposes, and so long as 9 is clarified, specifying what the access is, then the concerns about lack of precision are overcome.
And Mr. Vest, can you find me the reference for that? Not necessarily now, but if you could follow that up and send that to the case officer, and make sure that you're copying the council if we can get agreement with the council on that. And we may need to polish up the wording of 9. Thank you. I think I've heard everything I need to on that. Condition 12. No occupation until pedestrian visibility displays are provided. I have no comments on that unless anybody else does. Condition 13. Another pre-commencement condition. Again, we seek to be requiring more plans to be submitted. I mean, is this reasonable? Is it necessary? Detailed plans including levels, sections, construction details, proposed road surface, water drainage, fouls. Oh, sorry, I'm on the wrong one. The pallet should be occupied until... No, I am on the right one. Details of plans. Is this not covered in a plans compliance condition, or do we not have a suitable level or suite of plans before us that would show all of this level of detail? I mean, just what we're trying to achieve with this condition. We've got sections of construction details for proposed roads. We've already covered surely through a section 7A. We've got, and shown on plans, we've got surface water drainage and foul, sewers, outfall, disposal. Is that not already covered by drainage schemes that are going to be submitted through other conditions? So your view is that these issues are not covered in the set of plans that are before us. Therefore, additional plans are required to deal with these matters.
Yeah, what I'm just double checking is
Just while you're doing that, I'm just going to turn to the appellant to seek their view.
Yes, I think the condition probably needs a little refinement because Ms Barnes has just highlighted surface water drainage. I think we've provided outfall disposals covered in the surface water drainage strategy and indeed by conditions elsewhere. But, for example, we haven't provided constructional details of the proposed road. There's a question mark as to whether it's necessary to do so, but the appellant doesn't have an issue providing those details.
Mr. Taylor, do you or Miss Barnes?
I was going through the proposed road. I think that is surface water doesn't the plan quite a good.
But yes,
I think how tourism by how foul drainage conditions said.
Sorry, I don't think it's covered by condition 8 that we've already been through, so it may well be useful to keep it in at this stage, but as Ms Barnes said, I would need a bit more time just to double check.
On the project it's relatively drainage.
can I just to give me some confidence? Can I ask Mr. Barnes and Mr. Taylor to maybe liaise with each other and just check the details of on that particular condition in terms of what is needed? Because I mean, it's clear surface water is covered elsewhere. I can see that things like potentially street lighting isn't. Road construction might be, might not be. Whether that's through the highway agreement or if actually we do need some plans. And can you provide a response to me outside of the hearing? And I'll take that representation. I mean, I don't like doing that, but I think it's necessary.
Maybe that could happen 5 minutes later. Technically the hearing.
Let's move on then. Condition 14, no occupation to parking provided. I have no comments on that unless anyone else does. Condition 15, no occupation to cycle parking provision. I did wonder if that could potentially be merged with condition 14. Any thoughts on that? Silence is no thought.
No objection to that change.
Okay. Condition 16, dealing with contamination. The inspector does have some standard wording in regards to land contamination. I hope the parties have probably seen in other decisions. But would the parties have any objection to me refining the wording of that condition? No?
No objection, as long as it meets the same goals as the wording currently.
Thank you, Mr. Taylor. And condition 17 is a pre-commencement condition. We're looking at an emissions mitigation assessment, air quality assessment, in accordance with the air quality and emissions mitigation guidance. I'm just wondering, why is this reasonable and necessary? Taylor?
Thanks. I was just turning up the relevant consultation response from the Environmental Health Officer. It was a condition requested by the specialist officers in the shared service of pollution control due to the scale of the application and its major development status. The air quality emissions mitigation guidance for Sussex is relevant to the development and that the guidance recommends that prior to commencement, an air quality impact assessment and mitigation cost calculation is undertaken. So I think the condition has been imposed at the request of the specialist advice received.
What's the trigger for complying with this condition?
It's a prior to commencement trigger point, I believe, and the assessment must be agreed with the LPA in the form of a mitigation statement. So that would be the trigger point and the work required from the appellants.
And where is the requirement for the implementation?
I think that is missing, and so if you're happy with the condition, would need to be added.
And what do you think that should be?
What the
Sorry, sir, I was a bit slow there. My view would be that it should be that the development should thereafter be commenced or carried out in accordance with the approved details and maintained for the lifetime of development, or something similar to suit the wording that you might want to use to tidy up. But that would be my view.
Great, that's fine, I can do it. I mean, it's an important learning point, isn't it? Because we could have compliance with we could have, the appellant going to some expense to put something together for approval, then the condition doesn't actually require it to be implemented. Does the appellant have any comments on this condition?
So I think we'd like to understand timing. So in the first sentence, prior to commencement, as you pointed out, it's a pre-commencement condition that the assessment be undertaken. There must be some provision for the submission of that assessment to the local authority and approval by them. Then at what stage? Because if this is all prior to commencement, it's going to take time and cause delay, and then there must be a requirement to adhere to the approved scheme. I think for our part, we'd like to hear from the local authority why this has to be done before commencement. There may be good reasons, because it might have some effect, but plans are being approved, so it won't affect the plans. And what is it designed to achieve?
Slight query. Based on what Mr. Taylor's explained, I'm struggling to understand why this condition would apply to a major development of 11 new homes, but not to a development minor, 9 new homes. Rationale put forward, this is necessary because it's a major development, and I can't see that a minor development wouldn't similarly have an impact, albeit a slightly smaller impact.
I think I can deal with the last point, but then I'm afraid the earlier points I'll have to pass over to Mr. Taylor because it's outside my knowledge. But I think the point is that it's all about materiality and extent of impact. So with a smaller scheme, it's just not proportionate to require this because the impacts on air quality will be less. And for schemes over a certain point, and you have to have a sort of bright line rule to determine that the impacts on air quality are greater, and therefore it is proportionate and necessary to carry out this exercise. Mr. Taylor, are you able to help a bit more with the rationale for it?
I can attempt to, but obviously not being an environmental health officer myself, I'm not fully versed in the thinking behind that specialist officer's request. It would be obviously helpful to have a specialist person here to fully justify the thought process behind requesting that condition to be imposed.
Well, if I could just pause you there for a moment, Mr. Taylor, because you shouldn't need to be a specialist in environmental health, because has to be a planning reason for the imposition of this condition. I'm going to ask, what is the planning policy rationale for the imposition of this condition that might make it necessary or reasonable? I mean, I can see in the reasoning you've given reference to spatial planning objectives, SPO 13 and policy WC 14, core strategy, and safe policy EN 27, which I think as we've came up as a general amenity type policy. Is there anything else in those policies that would specifically require this?
Yes, those policies are cited in the reason for the purposes that they deal with amenity impacts. I think the framework also speaks to numerous throughout various paragraphs, particularly 183, 185 and 188 about pollution and impacts that air quality can have. And as Mr. said, obviously on a larger scale, that is clearly above the threshold between 9 and 10 dwellings here. It is a major scale, and the construction and ongoing impacts of that would, I think, in the council's view, necessitate the imposition of this condition. Like I say, following advice from the health officers, and that would be the policy, the hook, if you will. Like I say, paragraphs 183, 185, 188 of the BPF, and then SPO 13 and E 27 from the local plan.
Thank you, Mr. Taylor. Anything else from the appellant on this before we move on?
We're not convinced that this is necessary.
Quality management area in Wilton District, so there isn't a problem we're necessarily trying to solve specifically.
The LPA want to come back on that point?
Well, I'm afraid I don't know the details, but presumably there wouldn't be air quality and emissions mitigation guidance for Sussex if there wasn't an air quality problem in Sussex. So presumably what this condition is trying, the planning rationale which you referred to, is protecting against unacceptable air quality pollution with all the health and amenity effects that has. I find it harder to answer whether it needs to be a pre-commencement condition or whether it could be, for example, prior to occupation. I mean, I suppose the rationale for it being pre-commencement is that depending on the outcome of the assessment, there may be steps that need to be taken on early in the construction and development process, but I'm speculating. I'm afraid I just don't have detailed information about it.
I mean, I'm going to try one more time and put this to Mr. Taylor, actually, if I can. What is the planning justification for this condition, and what is the planning objective that it is trying to achieve?
I think the section 3 of the air quality and emissions mitigation guidance for Sussex sort of sets out the planning rationale for it, in that major developments identified by the document's methodology will require an air quality impact assessment. The purpose of this is to determine the significance of the impact of a development on local air quality, and that assessment should be carried out by the developer. I think, as I mentioned, there's a policy basis, as I've already set out, is the rationale behind it. But beyond that, so I would be restricted on what I could advise you.
Okay, I think I've probably heard enough on that. Let's move on then, if there's no further comments from either side on that condition. So, condition 18. I often think of conditions worded like this are a pre-commencement condition in disguise. Before preparation of any groundworks and foundations, to me that is a pre-commencement condition. And I read it as such, so we would need to seek approval or agreement from the appellant to that. A landscaping plan submitted, approved and implemented as approved is the notes I've got here. We already have a planting scheme, don't we? In fact, I'm looking at the landscaping planting here to some degree that I've got in front of me, one of the plans. I've got other plans, I think, that show actual planting schedule. This one.
Is this not those hard landscaping? Or is that what you're looking at? So it's not landscaping in a plant sense, but in terms of materials, boundary treatment, steps, railings, retaining walls, that kind of thing.
So we're looking at block paving and surfaces and such like, are we?
Landscaping is maybe a slightly romantic term, yes.
I think it probably is in this context, but I appreciate the subtle distinction. Are those details currently lacking from the set of plans, Mr. Best?
Yes, sir, they are.
Okay. I think that's an easy answer then. I will move on that point. Condition 19, we're now talking about soft landscaping, I think now, the term would be. I have no comments on that, unless anyone else does. 21, development carried out in accordance with preliminary ecological appraisal recommendations. I have no comments on that unless anybody else does. Condition 22, again a pre-commencement condition. Again another pre-commencement slightly in disguise. But we're looking for a scheme here. Landscape and ecological management plan for the ancient woodland. I don't have any issues with that unless anybody else wants to point. No. Condition 23, wildlife management plan submission, approval and implementation. I just wondered on this, why would this not be achieved by condition 21? So we've got, we're talking wildlife, we're talking preliminary ecological appraisal, phase 2 ecological surveys in 21, of which there'll be recommendations in. I know we've not discussed those at the hearing. There'll be recommendations in there, I'm assuming, unless someone tells me otherwise. And yet it looks like we're looking for a full scheme of some kind to be submitted under condition 23. Why is more detail required on that, Mr. Taylor or Ms. Barnes?
I'm afraid I don't know the content of the ecological assessment, so I'd ask maybe Mr. Taylor is able to help with that, whether they do in fact include a concrete scheme. A bit unfortunate in the context of ecology, but you know what I mean.
I think condition 23 may well be a duplication, sir. I don't think the LPA would object to it being in light of condition 21's presence. I think it was 21, wasn't it? Yeah.
So it would be the LPA's position that that condition is no longer required?
That's correct.
Due to the overlap with condition 21?
Correct.
The appellant side, any comments on that? Thank you. Condition 24, we're looking at a sample of materials submitted, approved and implemented. Again, is this detail lacking on the plans, Mr. Best?
I don't think we specify the type of bricks and things like that, sir. So I think this condition probably does add this.
And the trigger, before construction above ground level. How about before first use on site?
I'm sorry, just another point. I'm just checking whether it's covered by 18,
By which one, sorry?
by condition 18. The details shall, that's the hard landscaping one. These details shall include proposed boundary treatments, proposed finish levels and contours, hard surface finishes.
Do we draw a distinction between landscaping and the actual development itself, though, in terms of the houses? I think my reading of this was this is brick samples, tile samples, those sorts of things. But I could be wrong. I'm happy to be corrected.
I'm being told to my left exactly the same thing, so I'm sorry. I just wanted to flag it, but ignore that comment from me.
Any comments from either side on that? In terms of that trigger, I was just suggesting that.
Sorry, sir, could you repeat the question?
Well, the trigger is before construction above ground level, the dwelling is hereby approved. Just wondering if the more suitable trigger is prior to the first use on site of said materials.
So if it's prior to the use of the materials, it's when you said prior to use that I...
No.
Yes.
Let's...
Because we're happy, the materials have got to be approved before you
use them.
So yes, sir.
These are more precise way of expressing what this condition is trying to achieve.
I think before construction above ground level was trying to achieve precisely that, but is your point, sir, that you could be building the sort of internal part of a wall before you go ahead and...
I was not suggesting that. But
well,
I just think, can we...
I'm sure that further precision would be fine.
It's a relatively minor point.
Yeah.
It's a sensible alteration, if I may say so, sir, because if it's before construction above ground level of the dwellings, it appears that you have to get approval of all the external surface materials before construction of any of the dwellings. But if it's prior to use of the materials, it makes absolute sense because there are different materials that will be used on different dwellings.
And we're talking about external surfaces. We're not talking about internal block work. Going back to your point, Ms. Barnes, yes, you could potentially construct block work that may have a render of finish of some kind, or...
Yeah, so as currently drafted, it could cause unnecessary delay.
Yes.
Yeah, so yes.
Okay.
That's fine.
Worth touching on that, even though it is a minor point. Condition 25, then. Plans proposed footpaths around the two World War II pillboxes. Is this not in the plan? Are we talking about the details of how they'll be constructed or the location? Because we're talking about detail of the proposed footpath location and construction methods. Do we not have that location already on the plans?
Sorry, if I could answer that one.
Go for it.
If I could refer you to the site levels and contours plan, which is 11723/1100/P2. And
I'm
just,
going to ask you for that reference again. I'm
sorry.
I'm not that quick.
I'm speaking quickly, that's fine. So 117
23
/1100 P2. You will notice the proximity of the southern pillbox to the contouring, which follows the edge of the footpath, which follows the edge of the drainage pond. And the very close proximity of those elements. And we are worried, or in heritage terms, we're worried about the particular setting of that pillbox. and whether any of those works would undermine it.
Any comments from the appellant?
No, sir, and you will recall that when we were discussing heritage, the council's position was they didn't pursue the point in relation to the pillboxes subject to the conditions. So that's why these conditions are important.
And that was conditions 1 and 2, as well as 25, and the next one we'll come on to.
1 and 2 was archaeology.
Was to do with the archaeology, which includes historic building recording.
Okay. Moving on to 26, which again is in relation to the pillboxes. I don't have any comments on that unless anyone else does. 27 is pre-commencement noise assessment. I've already seen a noise assessment in the documentation that's been submitted. Is that not sufficient? I assume referencing this condition WWTW is wastewater treatment work.
Correct.
I think it would probably be sensible to denote that.
Fine.
Mr. Best, do you have any comments or concerns with this? That's the question I'm asking.
I can see Mr. Taylor is looking for the noise assessment, so perhaps we could come back to you at the end.
Yes, we'll come back to that point then. Let's park that one for now. Condition 28, obscure glazing on side elevation windows that overlook rear gardens. I have no comments on that. Nothing from the parties? Okay, condition 29. No flood lighting, security lighting, so on and so forth. Is this not development that would require planning permission? Therefore, is this condition actually necessary and reasonable? I mean, we've already got details of street lighting going to be submitted, haven't we? Are we doubling up a little here? The best? Or have any thoughts?
Yes, sir. Lighting. Is a fairly rural development. Lighting.
Well, is there lighting proposed? My point. And if lighting is not proposed, then is that not development?
There's no lighting for start.
And we've already got a condition earlier dealing with the submission for street lighting. So what's this condition about? I say no restaurant shall be built on site until details of the restaurant shall be approved. You're not proposing a restaurant. See what I'm getting at? I can see some conferring with the council. I'm going to have to push you a little.
Yeah, I'm sorry we missed those.
I'm just saying what
Sorry.
I'm just saying what lighting, just to cover the point. Myself and Mr. Best had a brief exchange there. What lighting are we referring to here? If lighting is being proposed, we've talked about street lighting, and that's covered by another condition somewhere, which we've already talked about briefly. There's further lighting be proposed. I mean, there is no other further lighting being proposed. I was saying it's akin to saying, before a restaurant is built on site, but no one's proposing a restaurant. So it will be development requiring planning permission, would it not? So why the condition necessary or reasonable? And I was being slightly pedantic in my example, but it's an extreme example to make a point.
If I may, sir, I think the rationale behind it is the SS2 seeks to protect those trees that are within the site, protect those trees that are within the site and are within the appellant's ownership, just to prevent those trees from being impacted or removed part of the development. Impacted or removed part of the development.
I want it's a condition which is potentially inconsistent with 31. So you only need 31, you don't need 32.
Well, 32 deals with hedgerows, I just think as well, which I think Mr. Taylor there, which may not be covered by the tree survey. Is not to get too excited, but would it be a case of adding the words along the lines of beyond the recommendations set out in?
Yes. And we'd achieve consistency.
And then we would have no conflict.
So.
Yes? Good. And condition 33 is an approved plans condition. And the LPA suggested there might be a plans list.
Yes, has that not been sent through to you?
Do you think that's come through the case officer? Because I was hoping that the parties would see it and agree it here.
Has it? I thought it had been agreed. Has it not?
It has been agreed between Mr. Taylor and I. What we haven't had is a email from your case officer, sir, saying you agree. We haven't said yes, but between Mr. Taylor and I, we are agreed.
Let's just wind back a little. So a list of plans has been prepared by the local planning authority, discussed with you, and that's been submitted to the case officer from the local planning authority.
Well, sorry, and has been agreed between the parties. That's the stage that I think was listed out in that summary. Has it been submitted to the case officer?
No, not yet. We've only just agreed this morning, so we were going to ping that over to the case officer at the next available juncture.
Fantastic. That would be great. If that can follow our discussions today, that would be most useful. And if we could get that, before close of play today, that would be most. Okay. Thank you. I appreciate that process can be a little tedious, so I apologise for that. But I think it was worth going through, given some of the anomalies that we did pick up in the end. Again, can I just ask, again, stress the importance to the appellant of confirming in writing their agreement to any pre-commencement conditions, which I would need to ensure that we're meeting the associated statutory requirements.
I've got a little homework list, Sarah, and you'll remember condition 27, noise assessment, we needed to come back to.
We did, sorry.
I don't know how you want to deal with that. It may be that
well done.
We could have a slightly extended break for us to print our closings anyway, and during that we'd try and resolve the issues that you asked us to look at. Just a suggestion.
Yes, no, that would be useful. Let's return to that then. I was about to move on to closings, but I think actually let's have a short recess. So unless there's any other further comments on the planning conditions from anyone else. Mr. Best.
Just a very minor point. There's a formally disputed condition relating to foul drainage. And my assumption is that will become condition 34 in the event that you are happy with the revised wording Mr. Taylor and I will put to you.
Say that again to me.
So there was a formally disputed condition relating to foul drainage
That we discussed earlier.
we discussed earlier.
At the very start.
At
and
the
you
very
were going
start.
to put a new form of words to me, which
Yes.
was removing it from pre-commencement to prior to occupation.
Yes, and in the event you're happy with that, my assumption is it will become condition 34.
Or in there somewhere.
Or
Yes.
only it matters, sir, because I've got a list of pre-commencement conditions. If it goes in there somewhere, my list will be out of kilter, and the agreement I've given you might be.
Well, it would be useful when you send your number list through to just give us your,
Yes,
in what-
relating
in
to.
relation
Yes.
to.
Okay.
Oh, yeah.
So what would the implementation condition become then? I mean, normally that would be at the top. In fact, did we... 18 months versus... We did at the beginning.
Well, you've lost me there. Sorry.
Sorry, the the commencement period condition at the moment is not numbered. It's not in the list of numbered conditions.
No. It's my standard practice that you start with your timescale, and then you do your plans compliance conditions, and then you move on from there. And there is guidance in the PPT about how conditions should be ordered.
Are you happy then, sir, to just slot that? It's just so that we don't mess up the numbering that we've agreed, and for the purposes of our discussions, when you, well, in the event that you were to publish a list of conditions, you'd move that to the top and make sure that any other...
I'm not going to get hung up on numbering. I think it's the substance of the conditions, and so long as it's clear that when any agreement was given to a condition, you know what condition we were talking.
What I'm going to suggest, Sarah, is that when we put in, Mr. Best puts in written agreement to the pre-commencement conditions, he refers to the condition numbers in the statement of common ground,
Yes.
which will avoid any
Exactly.
confusion, and then he won't have to summarise in detail each condition.
Yes. Okay. Yes. I was just thinking you'd just said power water drainage, but yes, that actually would suit it. Perfect. And then we have an audit trail going back to that document. Absolutely. Good. Let's. That has taken a little bit longer than I'd hoped. Let's take a break. Let's come back from that break and then briefly resolve the noise assessment and mitigation condition, which is condition 27 in the statement of common ground. And then I will invite the parties to make their closing submissions statements to me. Again, 10 to 15 minutes on that. And then we will look at any applications for costs, we'll discuss the site visit arrangements, and we will hopefully close the hearing and move off onto site. All right? Let's break now until 11:30. Sorry, I should put the microphone on. Let's reconvene. And before the break, we were going to return to, we were discussing condition number 27, the noise condition. Has there been any progress on that?
Yes, sir. I've just reviewed the submitted particulars, and I can't see that a noise impact assessment was submitted with the original application. And I think some discussion during the break, tenants agree with that situation. Having reread the condition, I think it meets the tests. Therefore, however, I don't agree that it should be before preparation of any groundworks, because in this case that would be prior to commencement, as there's no demolition on site, and as the condition seeks to protect the immunity of future occupiers of dwellings themselves, it should be prior to occupation.
And the appellant side?
Yes, so we agree with that.
Thank you. I have no further comments on that condition or any of the other conditions. So let's move on. And as I said before the break, I would like to now invite the parties to make closing submissions to me. And then after that, we will discuss any applications for costs and the arrangements for the site visit. So I'm going to start with the local planning authority and ask Ms. Barnes if you would like to make your closing submission on behalf of the local planning authority for between 10 and 15 minutes, please. And if you've got a hard copy, that would be excellent. Thank you very much. And over to you, Ms. Barnes.
These closings are made on behalf of the local planning authority in respect of the above appeal. I won't read out everything, sir, just in the interest of saving time. The LPA's submissions focus on the principal areas of dispute between the main party. In summary, these are the degree of heritage harm that would be caused to various designated heritage assets, including consideration of any internal heritage balance, the public benefits arising from the proposal and the weight to be attached to them, and the implications for the planning balance of the absence of a 5-year housing land supply. The next paragraph just explains that I don't address the second reason for refusal in any detail, given that that has been agreed. And similarly, the third paragraph says the same in respect of the 2 pillboxes. Paragraph 4. Finally, by way of introduction, the LPA cautions against the inspector making any assumptions about the merits of the appeal from the fact that the decision to refuse permission was against officer advice. In this instance, there is a high degree of consistency of approach. The original officer and members accepted the advice of the LPA's conservation officer, Historic England, and the Sussex Gardens Trust that the proposal would result in less than substantial harm to the relevant designated heritage assets. The difference of opinion arose in that the original officer considered the harm was outweighed by the public benefits, while members did not. This was an understandable judgment for both to have reached in circumstances where the LPA fully accepts this is a case where there are compelling arguments on both sides. So turning then to the first main disputed issue, heritage harm. And I've tried to provide a brief summary of the key principles. So I begin by setting out section 66(1) of the Planning Listed Buildings and Conservation Areas Act, and that's the duty to have special regard to the desirability of preserving the building or its setting or any features of special architectural or historic interest which it possesses. As discussed, this duty does not apply to Buxted Park since it's not a listed building, it's a registered park and garden. Then I refer to the Barnwell Manor case, where it was explained that the effect of section 66(1) is that decision makers must give considerable importance and weight to the desirability of preserving listed buildings and their settings, such that considerable weight must be afforded to any harm when undertaking the planning balance exercise, and that creates a strong presumption against granting permission where heritage harm has been identified. I then refer to the Mordu case, where it was clarified that where a decision maker applies the heritage policies in the MPPF, they will normally be found to comply with Section 66(1). If you like, the MPPF is a route to compliance with Section 66. The key MPPF policies are 212 to 215. These make it clear that the MPPF envisages two types of harm to designated heritage assets, substantial and less than substantial. The PPG further advises, within each category of harm, which category applies should be explicitly identified. The extent of the harm may vary and should be clearly articulated. Compliance with the PPG is particularly important given that the Court of Appeal has recently confirmed in the MAJ case that the MPPF and the PPG have the same status in law, so the PPG is not subservient to the NPPF. Paragraph 212 of the MPPF also makes it clear that great weight must be given to harm to designated heritage assets, irrespective of whether any potential harm amounts to substantial harm, total loss, or less than substantial harm. So just because it's less than substantial harm doesn't mean that it shouldn't be given great weight, on the contrary. And it follows from that even though Buxted Park is not covered by Section 66(1), by virtue of the MPPF, the approach to be taken is effectively the same. So great weight has to be given to any harm identified. As for the so-called internal heritage balance, so that's where the heritage benefits of a proposal can be used to offset heritage harm, it was clarified in the Branshill case that this approach is permissible, but it's not required. So it's up to you, sir. A decision maker may alternatively elect simply to identify the harm and then weigh those heritage harms against the public benefits as per paragraph 215. Finally, the LPA reminds the inspector that the views of a statutory consultee, such as Historic England, should be given great or considerable weight, with a departure from those views requiring cogent and compelling reasons. So turning then to look at the specific assets in question, starting with Harrock House, which is grade 2 star. The dispute concerning the harm to Harrock House, a late 17th century rectory on an earlier moated site, is that according to the LPA, the proposal would result in less than substantial harm in the upper half of this category, while the appellant considers the degree of harm within this category to be low, prior to any mitigation. To state the obvious, Harrock House is not just any listed building. It is listed at grade 2 star, indicating that it is of more than special interest and of particular importance. Indeed, the consultation response from Historic England describes it as one of the most remarkable original rectories in the county. There seems to be broad agreement that its significance stems from its architectural interest as well as its historical interest as a rectory in relation to Buxted and later reconfiguration as a rural retreat. It is not accepted, however, that the historical interest is in any way secondary to the architectural interest. As for the contribution to significance made by setting and the site in particular, the site formed part of the glebe land associated with the rectory, which was located on an important route towards Canterbury, outside of the village and away from the church. This land is therefore important both in terms of understanding how the rectory functioned, even if a relatively modest proportion of the rectory's income was gained from its glebe land, as well as appreciating how the rectory would have been experienced at the relevant time, enveloped by its rural setting. Changes to the driveway and grounds in the mid-19th century, by which point the rectory had become a grand country house, mean that the site contributed to the sense of pastoral idyll surrounding the property. This rural setting was deliberately emphasised via designed views both in the property's 17th and 19th century configurations. At this time this pastoral setting was created, both the eastern and western parcels comprising the site were in use as pasture. The proposal will therefore cause serious harm, albeit within the less than substantial category, to Harrock House. That is because the creation of a substantial housing estate in the vicinity of Harrock House, in place of the existing arable field, means that the current sense of rurality, key to appreciating the glebe-land period and the later parkland period, will be undermined. This effect is exacerbated by the fact that the housing estate will be clearly visible from the designed views from Harrock House to the east, both from inside the property and from its garden, as well as from the access. To make matters worse, the estate has been designed such that the housing on the western boundary of the estate faces Harrock House, and the layout means that there are views into the heart of the estate itself from Harrock House, together with designed views towards Harrock House, which will be seen in the context of the new housing. The associated lighting, activity and noise from the estate will further erode the current sense of tranquility. Notably, both Historic England and the local planning authority consider that the level of harm lies within the upper half of the less than substantial category. Great weight should be afforded to Historic England's view as a statutory consultee. Moving on to Harrock House Lodge. The local planning authority considers that the harm to Harrock House Lodge, a mid-19th century lodge added to the environs of Harrock House when its driveway and gardens were remodelled, is moderate within the less than substantial category. In contrast, the appellant considers that the harm is at a low level within this category. In terms of the significance of the lodge, it is considered that the following extract from Historic England's listing report provides a helpful summary. The lodge is considered to be a well-crafted and aesthetically characterful example of a mid-19th century entrance lodge. Its special architectural interest is enhanced by strong group value with the Grade 2 star listed Harrock House. The historic association is further emphasised by the survival of one of the original gate piers, which is recommended for inclusion as a subsidiary feature. It follows that the significance of the lodge relates to its architectural and historic interest, with particular emphasis on its role in the aggrandisement of Harrock House in the mid-19th century. As for the contribution to significance made by setting, the rural open land alongside the lodge and to the east of its connecting driveway to Harrock House was an important element of the grand entrance to Harrock House, facilitated by the mid-19th century remodelling. In particular, its function as a lodge building with associated gate pier as part of this larger ensemble adds to its significance in terms of providing security at the entrance to the estate and giving off the public impression of status and importance beyond the road. Notably, at the time of development of the lodge, both the western and eastern parcels of the site were in use as pasture and would have been appreciated together as part of the Arcadian character of the setting. The proposal fundamentally alters the aforementioned bucolic setting, which remains highly apparent today, by introducing dense built form via a housing estate to the eastern side of the lodge and its driveway, and associated urbanisation of the A272. As with Harrock House, the impact of this is exacerbated by the design of the estate, with the houses on its western side facing outward. These outward-facing houses would be especially visible from the first floor rooms of Harrock House. Turning to the internal heritage balance, the appellant contends that the restatement of the western part of the site from arable use to pastoral parkland, along with the relevant field boundary, constitutes a heritage benefit of sufficient magnitude to outweigh all the harm that would otherwise be inflicted by the proposal on Harrock House and Harrock House Lodge. In contrast, the LPA does not consider this to be a material heritage benefit, and certainly not one which carries anything more than very limited weight. That view is shared by Historic England. Theoretically, there is potentially some heritage benefit from reinstating the former use and therefore character of the western part of the site. However, this is not in reality what is proposed. Rather than being unspoilt pasture with grazing animals, the eastern field boundary will be grassed with a public footpath around the outside. It will therefore be read more as a public park than genuine pasture. Similarly, the hedge boundary to be reinstated is not a traditional field boundary, but an ornamental hedge to be maintained at a height of only 0.6 metres. In any event, even if the proposal was effective in giving the eastern parcel a real sense of pasture, this would be of limited benefit given that the current arable use is broadly similar in appearance to the previous pasture use, especially when perceived from a distance as one would from Harwick House and/or its driveway. What matters for the purposes of significance is that the use of the site as a whole retains its formal rural character, which is precisely what is achieved at present, and indeed that's recognised by the appellant. Importantly, however, any heritage benefit also needs to be considered in light of the proposal more broadly. As pointed out by Historic England, any benefits resulting from the reinstatement of the pasture to the western part are only material if the eastern part also maintains its current rural character. As per Historic England, the reinstated meadow does not contribute meaningfully to the significance of Harwick House without the eastern field. The two fields together created the intended bucolic setting. Under the proposal, the bucolic setting arising from the eastern parcel is lost in its entirety through the replacement of the existing arable field with a suburban housing estate. In these circumstances, the appellant has exaggerated significantly the positive impact of the proposed pasture reinstatement. Moving on to Buxted Park. So here the local authority's position is that the harm is in the upper half of the less than substantial category, while the appellant puts it at low. There's broad agreement as to the significance of Buxted Park, and I've put a quote there from the appellant's appeal statement. That's agreed by the local authority, which emphasises Historic England's view that Buxted...
Ms Barnes, I hate to interrupt, but you are approaching 15 minutes.
Ah, right, okay, I will speed up. Anyway, there's a quote from Historic England's view, remarkable Historic England interest, and the point about telling the story of Buxted Village and its relocation. In terms of contribution made by setting, it forms part of the rural context, and that matters because it helps tell the story of how Buxted developed from a rural settlement within the park to a separate settlement to the northeast. It's also important to appreciate that the site lies adjacent to the part of Buxted Park with historic features of particular note, and there in particular I'm referring to the earlier deer park. The result of the proposal is that modern housing will be visible from a particularly sensitive and historically important part of Buxted Park, the northeast part of Buxted Park adjacent to the site. That will impede visitors' understanding of how Buxted Village was moved from within the park to a visually separate location, so as to facilitate the development of the mansion within a parkland setting. And then I point out that that is the view of Historic England, but also the relevant statutory consultee, the Sussex Gardens Trust. Mill House, Old Mill and Linden House. Maybe the best thing to do there, sir, is to leave you to read that in your own time. Moving on to Hog House. There, the local authority considers that the harm would be at the low level of the less than substantial category, while the appellant contends that no harm at all would arise. And essentially, that there's agreement as to the contribution to significance made by the site, in that the appeal site forms part of the surroundings in which the house is experienced, principally in terms of its approach along the A272, where the site forms part of the wider rural surroundings. And so the point is that creating a sizable housing estate in the vicinity of Hog House along that route with the associated urbanisation of the road erodes the current largely rural setting. And that undermines one's understanding that Hog House was deliberately located close to but separate from the medieval village of Buxted. Moving on to public benefits, and I've just repeated there the points that I made orally during the hearing about the Vistry Homes case, so I won't repeat that there. And then at paragraph 48, I've just summarised the evidence of Mr. Taylor in respect of each of the alleged public benefits. The key point being that his evidence is that overall the benefits are considered to be significant. Turning to paragraph 49 then, taken collectively, the local planning authority does not consider that the above benefits outweigh the harm to heritage assets that result from the proposal as 215 of the MPPF requires. That is because the heritage harm here is serious, albeit falling within the less than substantial category, especially to Grade 2 star listed Harrock House, which by virtue of its listing is of particular importance. The remarkable nature of Harrock House and its sensitivity to change within its setting should become even more apparent when the property and its gardens are viewed by the inspector on the site visit. As per the MPPF, this harm and the harm to the other designated heritage assets too must be afforded great weight. In those circumstances, while the local planning authority recognises that the public benefits are significant, they do not outweigh the heritage harm identified. And then finally, I address the question of paragraph 11 and the absence of 5-year housing land supply. This was what we discussed yesterday. It's agreed that paragraph 11 applies. It's a material consideration that you need to deal with, sir. Our position is that from paragraph 51, so having considered whether the proposal complies with the development plan, the inspector will need to address as a material consideration the tilted balance in paragraph 11. The lack of 5-year supply means that paragraph 11D is engaged, but the effect of paragraph 11D1 is that the tilted balance is not applicable. That's because, for the reasons already given, the heritage policies in the MPPF provide a strong reason for refusal, in essence because the public benefits do not outweigh the identified heritage harm, which must be afforded great weight, and you're therefore invited to dismiss the appeal. Thank you for slight leeway with the timing.
Thank you, Ms. Bantz. I appreciate that. Mr. Cameron, if I can now turn to you and invite you to make your closing submission on behalf of the appellant. Thank you.
Sir, I'm conscious of what you've said about time, and therefore much of this is in rather note form. The aim is to provide you something useful when you go back to consider the case. And the headings I've got are decision-making framework, impact on the European sites, impact on the significance of heritage assets, then public benefits, then heritage balance, then the overall planning balance. But in these oral submissions, I'm going to concentrate on impact on heritage significance. That is the point, really, at issue between the parties. So on decision-making framework, I am not planning to read that out, but I've set out the appellant's position on the development plan as set out in the appeal hearing statement, and I've identified other material considerations. Paragraph 30, I address paragraph 11 of the MPPF, but I'm only restating what I said yesterday, so I won't read that out. The SPA and the SAC, not in dispute between the main parties, but you as competent authority are going to have to turn your mind to this issue and make a decision, and therefore I have set out our position on that. I'm now going on to page 6, impact on the significance of heritage assets. And can I just say, Ms. Barnes sets out principles from the case law, all agreed, apart from a slight gloss on paragraph 11 of her submissions, which is how you deal with the views of statutory consultees. And this I deal with at paragraph 84 of my closing, where I refer to Shadwell Estates and then to a subsequent case, Newcastle case, where the court expressed some disagreement. My submission is those responses from statutory consultees are important. They are material considerations. They have to be considered, but they don't have to be followed and accepted. And if you disagree, you have to give reasons. And the reasons, it said in Shadwell, have to be cogent and compelling. In fact, the reasons have to meet the normal standard of being adequate and intelligible and dealing with the substantive points made. The only different submission I make. If you're doing it, you might as well make them cogent and compelling. So turning to the impact on the significance of heritage assets, I start at 45 with the definition in the glossary to the framework, because that is what we're dealing with. And as you set out, when you set out your agenda, we went through, it's important to ascertain what the significance is. And to do that, you need, in relation to each asset, to identify whether it's got archaeological interest, architectural, artistic, or historic. It's only if you do that that you can properly assess the impact of a proposal on significance. The council signally failed to do that in their analysis, and again in their closing, however attractive the narrative is, doesn't deal with those specific points, and I intend to do so. As far as less than substantial harm is concerned, the extent of harm should be articulated. The PPG tells us that. I'm at paragraph 47. How do you do that? Well, if it's less than substantial, as the word suggests, it's got to be lower than substantial. So if substantial harm means seriously affecting a key element of its special architectural or historic interest, less than substantial must be below it, and a high level of less than substantial must be close to substantial. And I do rely on and refer you to the approach that the inspector took in the Edith Summerskill House appeal decision. And I set that out at paragraph 50. So I turn to Harrock House, grade 2 star. So on significance, it has archaeological significance for evidential value. It has historic value, association with the iron industry. That, of course, is not associated with the building on the site, because the building on the site came after cannonball manufacture and so on. Long use as a rectory. Construction and materials are typical of a late 17th century building. There was extension, renovation and aggrandizement, using Mr. Maguire's words, in the 19th century, and the addition of a lodge. and the setting, in particular the lodge, the drive and the parkland, makes a contribution to historic interest, architectural and artistic, substantial degree of aesthetic value, got the half-H form, symmetry appreciated from the driveway, quality brickwork, 1850s Gothic revival mullioned windows, service court at the rear added in the 19th century, and the setting, and in particular the lodge, drive and parkland, also make a contribution to architectural and artistic value. I then turn to contribution made by setting. Setting makes no contribution to the archaeological interest of the listed building. Architectural, green space around the building, using Mr. Maguire's words, allows one to experience architectural interest, but the setting makes no contribution to the materials and design aspects of architectural interest. As far as historic interest is concerned, the appeal site did once form part of the glebe land associated with Buxted Rectory and therefore does contribute to historic interest. The Parkland stippling on the 1899 map shows that the parkland was on the western part of the appeal site. That has been lost because of the creation of a single large arable field. And then the formal entrance along the driveway also contributes to setting. So then one comes to, well, what impact will the proposal have on those values? Archaeological, I would submit, none. Association with the iron industry, no impact, that remains. Association with Christopher Wren, if there is one, none. Long-term use as a rectory, none, because that has already ended. Building materials and style, none. Aggrandizement in the 19th century, positive as a result of reinstatement of Parkland. And Ms. Barnes refers to the Historic England response. It is right that they refer to the relationship between the western and eastern part of the appeal site. It's also important to note at page 5 of their response, they recognise restoration of the past of Parkland as a heritage benefit. So I just add that to the note in response to Ms. Barnes. The development of the former glebe land has a degree of negative impact. That's always been accepted by the appellant and their advisors. As far as the artistic and aesthetic interest, in relation to the aggrandizement in the 19th century, the impact is positive as a result of reinstatement of Parkland, and development of the former glebe land will have a degree of negative impact. As far as the Parkland is concerned, the arrangement of the land as parkland with trees and pasture is going to be reinstated because the planting plan will reflect the record of where there was planting at the time that it was parkland. So the appearance will be parkland and will be a heritage benefit. So if one actually analyses what the impact is on the values or interests, it is not great, it is low, and the overall conclusion is that setting is preserved because of the benefit through introducing reinstated parkland. And I go to my 56. In the light of the guidance given in the PPG and the approach set out in the Edith Summerskill House decision, it's difficult to see how the impact on the significance of Harwick House could be in the upper half less than substantial harm as suggested by the Council and Historic England. That's if you go through a methodical approach. Harrock House Lodge, and I won't spend so long on this because I've set this all out. Significance, archaeological, because it's from a period where a large number of buildings remain, is not great. Historic, good example of a mid-late 19th century lodge. Group value, Harrock House. It forms part of the aggrandizement of Harrock House in the mid-19th century. And the presence of Parkland on the appeal site would have formed part of this planned entrance experience, and therefore an important element of the setting of the lodge. But as with Harrock House, this contribution has been diminished by the modern conversion of the site to an arable field. And then on architectural interest, the list entry reasons for designation are particularly useful, and I've set them out. So the contribution made by setting its group value with Harrock House, and it was a crucial part of aggrandizement of Harrock House in the mid-19th century. There is some erosion of the wider rural setting, but for the lodge in particular, the restoration of Parkland is extremely beneficial because it was all part of the aggrandizement, so there is no net harm. I go to Buxted Park, registered park or garden, and if one looks at what is it that makes it significant, historic, the boundaries remain. There are associations with Lord Liverpool, the Prime Minister's, then Prime Minister's brother, and the historic village of Buxted. Historic buildings lie within the registered park or garden, Buxted Park House itself and St Margaret's Church. And architectural artistic, it's a planned landscape. And so that is of clear artistic and architectural interest as well as historic interest. But when one gets to contribution made by setting, the appeal site forms part of the rural hinterland to the park. So what will the impact on significance be? There'll be a small heritage benefit through restoration of Parkland. There will be harm through visibility of built form on the appeal site. When you go there, you'll see that it's limited, so overall low. And it can't possibly be in the upper half, less than substantial. Hog House, I won't go through all this, but the site does not make a material contribution to the setting of Hog House. It was part of the original village, is retained on the edge of the park, and there's no adverse impact on the values which contribute significance. As you will have to, I've dealt with Old Mill House and Old Mill together because they're related, but you will have to deal with each listed building separately. The main relationship between a mill and the mill house is with the river that drove the mill. And there is some impact, but it is low, and similarly with Linden House. The pillboxes is now agreed, subject to conditions, no harm. And then when we get to 83 and 84 is my response on Shadwell Estates. So that is, and I'd invite you to take that systematic approach to assessing what's the significance, what are the values, and what is the impact. And if you do that, you get a logical and clear answer. As far as public benefits are concerned, I'm not going to set them all out again. They're set out in the table at 7.2.3 in the Statement of Common Ground. There is some dispute on whether certain elements are public benefits that can be taken into account, and there's a dispute on weight. But Mr. Best gave very detailed evidence on that, and I don't repeat it. I have sought to identify issues in dispute and to address them. And there are benefits which the Council's officers advised should be taken into account as benefits and were recognised in the officers' report. They're B, D, E, H and I in my list at 87. And there's no good reason to take a different view now. The members may have taken a different view on the balance, but there's no indication that they decided that certain benefits were not benefits. Benefit A, which is the small and medium house builder point, there's no condition or obligation requiring the appellant to deliver it, so it's better termed as consenting a small to medium-sized site, is referred to in paragraph 73 of the MPPF. I won't read this out, but these are all extremely important benefits. And there can be no dispute that the provision of, I'm at 98.
Sorry to interrupt, Mr. Campbell, you are a little over 15 minutes now.
Yes, I'm aware I'm going to hopefully take no more indulgence than Ms. Barnes, but I note it and I apologise. So there can be no dispute the provision of housing and of affordable homes should be given very substantial weight, given the long-standing housing land supply shortfall in Wealden and their difficulties in addressing it. On the balance, on the great weight point and the considerable importance of weight, I do draw your attention, which I haven't done in writing, paragraph 75 in the City and Country Bram's Hill, which was a reference I made when you asked me a specific question. How do you deal with great weight? You've got to look at the value of the asset and the extent of the harm and form your own judgment. So on striking the balance, the benefits of providing housing, including affordable housing, in an area with a shortfall in supply are very substantial. And that and the whole list of other public benefits must be weighed against harm to heritage assets through development within their setting. You can either apply the net internal balance or not. If you don't apply it, then you've got to give the heritage benefits recognised by Historic England as a heritage benefit in the balance. And there is no good reason to depart from the approach taken by officers in their report to the committee that giving considerable importance and weight to the desirability of preserving the setting of the list of buildings, the public benefits outweighs the harm. That was on the basis of a higher level of harm. They still thought than that assessed by the appellant. They thought it was in the upper level of less than substantial. They still thought the public benefits outweighed the harm. There's no good reason to depart from that. So I invite you to find that the heritage balance should be struck in favour of the scheme. That means there's no strong reason for refusal on heritage grounds. You then go on and apply the tilted balance. And you apply the tilted balance when you're dealing with the concerns and issues raised by local residents, including flood risk, impact on residential amenity. And given the very extensive list of benefits, it cannot rationally be said that the adverse impacts of granting permission would significantly and demonstrably, at that stage, it's not a flat balance, outweigh the benefits, given the strong imperative to significantly boost the supply of housing. So I rush through that, but for those reasons, on behalf of the appellant, I ask that you allow the appeal, and thank you very much for unusually, in a hearing, giving me and Miss Barnes the chance to make some closing submissions, and I hope that you will find that note useful.
the notes there on what you just said. It can be unusual, but helpful when I have legal representation in front of me to utilise that skill as best we can. So thank you very much to the advocates for doing that. Let us turn back then to our agenda. Going on to agenda item number 6 now. Applications for costs, site visit arrangements, and any closing remarks I may have. And we'll start by asking, are there any applications for costs that I need to be aware of? I'll look to the appellant side. Thank you. And the local planning authority? Thank you. That takes us on to the site visit arrangements then. It does remain my intention, having heard what I have, to close the hearing here, and therefore there would be no opportunity for any further discussion on site, other than I may ask particular features or properties to be pointed out to me, which is normal. So I'm looking for just factual responses. There would be no discussion at all. On the basis of what I've heard and the comments from interested parties that I heard yesterday, in relation to the site visit, I think it would be sensible to carry this out on an accompanied basis with a representative from both the appellant side and the local planning authority in attendance in order to gain sufficient access to where we need to go, and we'll talk about that. Okay. And do any interested parties wish to be present at the site visit, and can this be accommodated? Do any of the interested parties wish to attend the visit? Is it Mrs. Chitty and Mr. Murray? Is that right? And can that be accommodated from the appellant side? The permission can be granted for that. The LPA have any comments in that regard?
But then Mr. Murray, whether he's happy to let the other interested parties.
Well, I'm coming on to that next, actually. So my next question, Mrs. Hall, are you? Sorry again? My next question was going to be, what access can we get to the heritage assets that we have discussed? And maybe we'll take them in turn. And I'll look to the parties for a view on particular viewpoints that you would like me to consider whilst I'm on site from any particular heritage asset or within it or through it indeed. So let's just deal with these in chunks if we can. So Harrock House and Lodge. So where you indicated yesterday that you'd be happy for me to conduct a visit to your property, which is Harrock House, I understand. Is that still the case? You are still happy to facilitate that. And are you happy for the appellant and local planning authority to join me? You are happy with that? And are you happy for other interested parties to join me? I mean, I've only had Mrs. Chitty here. Yes? There is no other interested party that would like to attend? No? Okay, so it's just yourselves. Okay, that's fine. And in terms of the lodge, I don't think, but I'll look to the parties for confirmation, I need access into the grounds of the lodge. The lodge is right by the road, it's right by the access road and the public highway. I think I'll probably see, and from my preliminary visit that I did on Tuesday, I think I'll see everything I need to from public land. Would the parties be agreeable to that? Yes, my point is I don't think I need to be within any private land owned by the lodge.
There are photographs have been provided in one of the appendices for that, so yes. Fine.
And the appellant side, are you happy with that? Now, in terms of the old mill house and Linden House, Mrs. Chitty, you own the old mill, is that correct? And the same question to you, are you happy for me to come onto your property? And are you happy for me to bring the parties that we have here and Mr. Murray? Good. That's great. Because I was going to discuss Mill House. We've had nobody here from Mill House or Linden House, have we? The parties consider it necessary for me to enter private land owned by Mill House or Linden House. I'll put to the appellant. From the site itself, and anything I may view from the old mill, I presume. And the local authority, do you concur with that view?
Agreed.
Agree. Interested parties, any comments in that regard? Okay. Hog House, again, we've had nobody here from Hog House that I'm aware of. No? Are the parties content that I don't need to access any land owned by that property? Okay. And Buxted Park, I know there's a number of rights of way through this land, so I'll be able to see if I can gain full access to that. I did wander through it the other day. Are there any particular viewpoints, is what I was going to ask, in terms of Buxted Park that the parties would want me to have a look at? I think in the submissions that I've seen from some of the discussion, the view from the crest, ridge is it? I beg your pardon? Ridge crest, okay, that runs through the middle of the park. How far into the park is that? Yes.
If you're starting from the church, there's kind of a plateau at that point that goes some way into the park, and the ridge is kind of on the edge of that.
Will you be able to guide us to that point?
I will, yeah.
Thank you. Ah, right, okay. That's fantastic. I would like to see that, and a couple of other things I want to check. Are there any particular other viewpoints, either from Buxted Park or any of the other assets we've discussed, that you would like me to consider or experience, I should say, not just about views?
So there are a few paths that go down in Buxted Park. There is open access, so you can also wander all the way along the boundary, as people often do. But I would encourage as well us to walk down one of the two paths, and maybe you walk the other one yourself, and come out at the point where the lodge is.
When you refer to lodge,
Sorry, the lodge on the eastern side of the park.
are we talking Hog House?
Uh,
Or the lodge?
Nope, sorry, that's on the western side. The lodge on the eastern side.
Oh, I beg your pardon, sorry. We're not
Where
talking
where
about...
the public footpath comes out. There's another lodge, sorry.
I was
on
going
the
to say, we've got
17th
lots of lodges going on
Yes.
here, or former lodges and
Yeah.
so on. So,
It's on the 17th century access end, which is on the eastern corner of the park, almost immediately opposite the access to the site.
okay, I'm happy for us to discuss broadly our logistics when we get on to site, because of course it'll be much easier there, which I don't think is straying into merits or hearing today at times.
So I'd suggest, if the council are happy, that we enter Buxted Park alongside Hog House, travel down the main drive, and across in front of the church, and then down the footpath to the northeastern exit at that corner. I think that would probably show us everything we
That facilitates us walking downhill, so I'm happy with that.
We have to walk back up a hill if we walk down a hill, of course. Okay, I'm content with that if the parties are content. Yes. The only thing I was just going to say is, well, firstly, how long do we anticipate travel time from here? I was thinking around 30 minutes. Is that generous? Is that too... Beg your pardon? Okay. Any advance on 40 minutes? So that's fair. My sat-nav will know the way, hopefully, and I have actually been once before, but I think I probably took a different route. Shall we say then to meet on site at... Well, first of all, parking arrangements. Where do we want to go to Buxted Park first? When you say on the site, this is an agricultural field. for the anglers.
I assume that includes walking within the site itself as well.
Oh, yes.
Yes. Okay.
Yes.
Yeah.
Yeah.
I think it would be useful to visit the eastern side of the site in particular, on the southern side. Yeah.
Great. Okay.
On site, there are some pegs which mark the division between the western and eastern fields. See that?
That's fine. I shall look out for that. So, are the gates open to that parking area? Man with the code. Can I ask that you go in advance and open that? Because I'm just conscious that if we've got a number of vehicles turning off the public highway, which is a fast-flowing public highway, into that field access, we want to do that as safely as possible. Go ahead, that would be excellent. So we'll park there on that area pad standing. Of course, residents can park at their properties if they wish and walk around and meet us. But in terms of a meeting time, should we say 1:15? Is that too ambitious? Meet on site about 1:15-ish, and of course we'll wait until everybody's there. I roughly know who's coming. I assume Mrs. Hall and Mr. Taylor, or
I'm happy to attend if
well, it's. I mean, I'm not compelling anyone.
I think Miss Hall will be more useful to you with the heritage input.
Okay. I assume the advocates will be looking out, or would you like to attend? Best of Mr. Maguire and Mrs. Hall. Okay. Mr. Murray. Well, as I've already said, Mr. Murray, there will be no discussion on site. I'll be wandering around the site and I'll be taking some photographs. I've already taken some photographs myself. And the purpose of the site visit is to place the evidence in context, is what us inspectors say, because we've heard all of the oral evidence and we've seen the written evidence. And it's about me being able to go with that fresh in my mind and place that into context on the site visit. I'm not inviting further submissions on the site. I won't be looking at documentation on the site. I will be literally surveying my surroundings and thinking about what you have all told me over the last day or so, and using that to assess the proposal. Okay? Good. Let's meet on site then at 1:15 with a swift getaway from here, parking in the Anglers parking area, and I think that brings us to our conclusion today, unless anybody else has anything else to raise. Mr. Taylor.
Just for transparency, I'll give you that unredacted 106.
Fantastic. Yes, just pop that there for me. That'll be great. All that remains for me to say then is to thank everybody for their attendance and contributions yesterday and today. It has been useful to have the second day. It's taken a little bit longer than I expected. But thank you all very much for your contribution and your time. And the hearing is now closed. Thank you very much, and I'll see you on site.